oftentimes we think of it in the exact opposite fashion, don't we? We normally think of copyright as being very, very restrictive. So let's keep that in mind as we go forward. I'm going to stop for just a second. There's a big live ongoing copyright case, monumental. It's actually in Georgia, and I'm going to talk about it in a little bit. But a court case, a court ruling came out about a week or two ago. And it's 129 pages, but there's a couple of sentences I want to read you that reflect what I just said here. But I thought it was interesting just because it's so current, like it's hot off the press. In what I'm about to read, I learned a new vocabulary word. You might already know this word, bailiwick. Bailiwick means sphere of sphere of interest. So anyway, I didn't know that word. So if you knew that, then you're ahead of me. But let me just read a couple sentences here, and you'll see how it reflects this. This is a court's opinion being read, and we'll talk about this court case coming up shortly. But it says, how much unpaid use to a creator or author or something like that, how much unpaid use should be allowed as the bailiwick of fair use doctrine. To further the purpose of copyright, we must provide some fair use taking of copyrighted material. This may be viewed as a transactional cost incidental to the business of authorships. If we set this transaction cost too high by allowing too much taking, we run the risk of eliminating the economic incentive for the creation of original works that is at the core of copyright, and by driving creators out of the market, killing the proverbial goose that laid the golden egg. And that right there in a nutshell is the tension that academic people like us live in. The law is designed to further knowledge. So there are lots of exceptions we're going to talk about in the law that allow us as educators to use even copyrighted material, fully copyrighted, where we can still use that in our courses for educational purposes. Why? Why can we do that? Because it furthers knowledge, right? But the courts have to be careful letting academics and whoever run wild with it, because if you run too wild with it, you do what? You hamper the incentive for creators to develop works. So there's always going to be this tension. That's why people say copyright is so gray. And we're going to try to hash out what some of those exceptions are today. And so you can have a better idea when you can and can't use copyrighted materials in your course. Okay. That court case that I just read that from is from Georgia State University, and it's a monumental case going on right now. And like I said, we'll talk about that in just a little bit. Okay. You could talk for weeks about copyright. I mean, goodness gracious. I mean, you could spend weeks and weeks talking about this, but I'd like to keep ours focused in scope to what's pertinent. I mean, you don't want to hear me ramble about, random stuff. So the key things that we're going to center on today is what types of things have copyrights on them. That's important for us to know as educators. We need to know exactly what rights are granted when you say copyright. Is that one type of right, or is it more than one right? If it's copyrights, we'll clarify that. And then probably most importantly, we'll talk about how do you determine if you can use copyrighted material in your class. As educators, we all know there's oftentimes we need just a quick little snippet of something and we want to put it in our class, but we're a little unsure if we're going to get dinged by a lawsuit, that we'll talk about those types of things. Okay, we'll keep this really open and relaxed. So especially virtual people, feel free just to pop questions in as I'm talking. No problem at all. I'll try to stop and address those. Okay, so what has copyrights attached to it and what does not have copyrights? Let's begin there. Little bit of verbiage to begin with that'll help clarify a lot. You'll see this in a lot of copyright lingo. Anything that has two criteria, has a minimal level of creativity. Okay, it can't be a rock, or something like that, but something that has a minimal level of creativity. And when I say minimal, I mean minimal. Like if I scribbled a few clever words on a napkin it would probably meet the threshold of being, the minimal level of creative. And second thing is something that's in a fixed, tangible medium of expression. So as soon as I create, if I write a poem, as I write it, it's copyrightable because it's in a fixed, tangible medium of expression. I do a painting, the painting is in a fixed, tangible medium of expression. If I paint an apple, I own the copyrights to that painting of an apple. Now, do I own the apple or the concept of an apple? No, I don't. But I own my expression of it. Does that make sense? Okay. All right. So things that are copyrightable, thinking along those two guidelines then would be like a novel, right? Obviously copyrightable. And some of these are like, oh yeah, I knew that, but some maybe might be new to you. Novels, articles, characters like in a book, letters, even diary entries. It does not have to be published to be copyrighted. In fact, I'll go ahead and give away something I was going to say later. You no longer even have to apply for copyright. Long time ago, you have to apply for copyright at the Copyright Office and all that. Since we entered into the Berne Convention, which is 1989 or so, 1988, 89 or whatever, things automatically now have a copyright. So if I wrote a little poem on my desk up here, as soon as it's finished, it's copyrighted, right? Websites are copyrighted. You don't have to put copyright 2000 whatever at the bottom. Things like that often help, to say, hey, this is copyrighted, don't take my stuff. But, legally speaking, you don't have to apply for a copyright to exist. Right? Plays, movies, music can be copyrighted, choreography, obviously art, even buildings. If you have a creative design for a building or something like that, it's in a fixed, tangible medium of expression. It's got a minimum level of creativity, copyrightable, right? Sculptures, things like that. Okay, what's not copyrightable? You cannot copyright an idea. No one can ever copyright the concept of capitalism, or something like that. That's free for everybody. Now, if you make an expression of that idea, that expression can be copyrighted. Why? Because it's in a fixed, tangible medium of expression. And that's how knowledge can still be furthered, because somebody can take an idea and make their interpretation of it, or a piece of artwork or things like that. But you never hinder or hamper the concept. You never hinder ideas, things like that. Facts cannot be copyrighted. 2 + 2 = 4. Nobody owns that, right? There was a court case, Feist versus Rural. It's an interesting case. I'll give you the short version. Basically, there was a big telephone book company and a small telephone book company. And I'm paraphrasing here, but just for brevity, the larger telephone book company wanted to get a compilation of phone numbers, addresses, that sort of thing for a huge region. And the way they achieved it was they not bought out, but they paid for phone listings from all these smaller companies in the region. I think there was 12. Out of the 12, there was a holdout, Rural. That's Feist v. Rural. Rural said, no, we're not selling you ours. Well, Feist took it and used it anyways. They took their phone listings and put them in their bigger compilation. So Rural sued. They said, you can't take that. That's ours. Well, the courts ruled that data was basically just factual. It's addresses, phone numbers. It doesn't meet that minimal level of creativity. Can't copyright it, right? So there's a lot of court cases that flesh a lot of these things out. Processes, you can't copyright a process. You can trademark a process, but it's not under copyright. Here's an interesting one. If there's only one way to express it, if there's just one way that you can express this concept, you can't copyright that. Why? Because, again, it doesn't further knowledge, right? So you can't be the only owner of that. And a great example of this was 1988. Apple, this was when computers were getting big. Microsoft copied a lot of the same structure, images, concepts for their computer as Apple started with. An example would be like a trash can, the trash can icon. So Apple sued Microsoft. They said, you can't use that picture of a trash can. That's our picture, right? For like an icon or something. Courts ruled you can't do that. Why? Because the only way to identify a trash bin is a picture of a trash bin. There's only so many ways you can express a trash bin, a recycle bin on a desktop. So they were not allowed to copyright the icon of a trash can. So that's a really interesting concept. Same thing if you have like a map. Maps are difficult to copyright because if a map's accurate, there should only be one way to draw a picture of South Carolina or Georgia. So things of that nature. Okay. Phrases and slogans cannot be copyrighted. It might be under trademark, like business logos and things like that. But short phrases and slogans cannot be copyrighted. Federal works cannot be copyrighted. Why? Because we pay we the people are integrally linked with the federal government. We in effect pay for the federal government or whatever, so they can't have copyrights that keep us from using in effect the things that the people collectively pay for. I actually ran into an interesting situation here personally. I was doing a training workshop and I was going to use a funny image of a Navy SEALs coming out of water. In any case, under the image, it said, because I was looking for the copyrights on it, because I just wanted, it's the kind of thing I like to be careful about. But under the image, it said, this image was taken by a sailor in the course of his daily duties as a sailor, but being a federal employee in the course of his normal duties, the picture that he taked was public domain. Anybody could use it. I was like, how cool is that? That's like real life in action copyright, copyright stuff. So I thought that was really, really interesting. Okay. And lastly, last type of thing that we'll talk about that's not copyrightable, and this one we'll go into more depth in just a moment. Things that are in the public domain. There's certain things out there that just don't have a copyright. Okay, and we'll dive into that. Let's just put a pause on that one. But there's certain things out there that just don't have copyrights on them. Let me not say any more about that until we get to that section. Okay. All right. Any questions on that so far?
Difference between a trademark and a copyright?
Trademarks have to be applied for. You have to apply for a trademark. Yeah. There are some differences between trademark and copyright. I'm not as knowledgeable on trademarks, but if something's trademarked, somebody has specifically applied to protect that brand, logo, things of that nature. Okay. All right. Next, let's talk about what types of rights do people get. If I make a poem or something and I sketch it out on paper, what can I do with that no one else can do? What type of exclusive rights are granted by Congress? Well, it's known as the bundle of rights. There's namely 5 rights that I have exclusively that I can do that really no one else has the right to do, unless there's an exception. And we're going to talk a lot about educational exceptions, teaching exceptions. Be a lot of what we talk about. But by and large, these are the rights that I have that are exclusive only to me if I'm the author of this work. Rights to reproduction. I'm the only one who can make duplicate copies of that item. I'm the only one who would be able to make derivative works. Derivative works would be like a second edition of a textbook, or taking a musical song and tweaking it, adapting it, and making it into a similar song. Maybe take the tune of Sweet Home Alabama, but maybe change a little bit along the way. You can't. Only the rights holders would have the ability to do that. That's called a derivative work. Okay. Rights to distribution. This one's often linked with the first one. Rights to distribution would be, I'm the only one who would be allowed to distribute large quantities of that work. but usually you don't have large quantities unless you've reproduced it. So usually those kind of go hand in hand. Rights to display. Let's say I have a piece of artwork or something like that. You couldn't take that piece of artwork and put it in the room across the hall and charge people $20 to come look at it. If I'm the rights holder, to that artwork. And the rights to performance. This would be like, if you have the Disney movie Frozen or whatever, taking it, you can't go show that in a public park to a wide audience beyond just family and friends, that sort of thing, because you would be performing that work or displaying that work to a larger audience than you would have the rights to. Now, if you, let's say I made a book and you bought a copy of the book, that's going to have different rights than these. You have property rights over that, but you couldn't reproduce my book. You couldn't make derivative works of it. You couldn't distribute it. You couldn't display it, or those sorts of things. But you do have property rights, meaning that once you bought, let's say my book, you could sell your copy of that book. You could tear it up. You could burn it. You could, I have no authority over to tell you what you can do with that copy of the book. Does that make sense? Right? But you could not do these things with it, reproduce it, and those sorts of things. Okay, questions on that? Okay. All right, let's dig in a little deeper into that public domain thing, because this is great for people in academics, because things that are in the public domain, by and large, are pretty wide open. You don't have to ask permission really from anyone, as long as something is in the public domain. The biggest one we need to talk about is the third one, but let's get through the first two first. Remember, some things are not copyrightable, like 2 + 2 is 4. You don't have to ask permission from anyone. And I'm sorry if I can't see you guys in the back. We maybe get some chairs here so I can see you a little bit. But yeah, that's fine. That's fine. I just don't want to be hiding behind the computer screen from you. Facts and things like that would not be copyrightable. Governmental works, like that picture of the Navy SEALs I was telling you about, I don't have to ask permission from anyone. I can just use it, right? Because it falls in the public domain. Things like that. Slogans and processes you have to be a little bit more careful about, because they might not have a copyright on them, but they might be trademarked, which might still prevent you. But if it's just a slogan that somebody uses but they haven't trademarked it, because you have to apply for that, then yeah, you can use it, because no one can copyright just a simple slogan or phrase. A lot of times, especially in academics, people will make things that they want people to use, in which case they can assign their work over to the public domain. So let's say I own the rights to something, and I don't want people asking my permission every time they want to use it. I don't care. Let's say I wrote a poem and I have no emotional attachment to this thing or whatever. You can assign your work over into the public domain and let it go, and then anybody can use it. That's becoming less and less frequent, because there's better mechanisms that have come along lately. I don't know if y'all have heard of something called Creative Commons, but we'll talk about that in a little bit. That's probably now the preferred way to let people use whatever you have created if you have no attachment to it, but they don't have to bug you for permission all the time. And we'll talk about Creative Commons towards the end of today. Okay. The most common thing that people think of when you say public domain is actually the third one here. Do you remember back on the first slide, I think you highlighted it, that it was for a limited time? Copyright is never forever. Well, I don't know if I should say never. In rare cases, there's perpetual copyright, but 99% of the time, copyright expires. If anybody writes a book, has a painting, whatever, why is it limited? Remember back to, what was the ultimate goal of copyright? To further knowledge. And how does it do that? It secures for a limited time to authors those exclusive rights. That's so they can make money off of it. But after a period of time, once it's been deemed that you've had enough time to make your money off of your book or your painting or whatever, then it releases into the public domain. Now, what's that time frame look like? It's life of the author or creator plus 70 years. Okay, so that leaves ample time for them to make, and their family to make money off of that particular work. After that time, it releases into the public domain.
Is that the death of the author or life of the author?
It's 70 years after the author dies. So it's the life of the author, and then once that life ceases, then an additional 70 years. Now, those rights after the author passes away can be left to a spouse or children. They can be left in a will. Like a lot of famous authors who have, well-known books, they'll leave the rights to their books to their children, and their children can continue to make money off of those books for an additional 70 years. Things in a more corporate setting, like businesses or companies that have copyrights for various reasons, those are 95 years after publication if it's like a work for hire type of deal, or 120 years after creation if it was never published. There are, like, if you want to get really deep into the public domain thing, there are some additional questions you might have, like, well, what about international copyright law? We're not going to get into all that today. If you do a Google search, Cornell has a massive list of when things fall into the public domain. I can get you the URL, but if you just Google probably Cornell public domain, you'll readily find it. It's a massively big list because these particular dates haven't always been what they are. Life of the author plus 70 years. That only came about since, I believe it was 1978 is when we had the last major revision in copyright law in the U.S. The good news is when we entered into something called the Berne Convention, that's an international copyright agreement. And I think it's like 168 countries are all part of that same agreement. So things by and large are pretty uniform now across the world. If you look at a globe, and I saw a map one time that had the countries who were part of the Berne Convention highlighted, and it was darn near everybody. So the U.S. was actually a holdout for a long, long time, which I'm not really sure why. I think it was because it was such a major overhaul. It was going to be a lot of work for us to revamp everything. What we finally did, and that's a good thing. That's where we got things like you don't have to post a copyright notice and things like that. So it's a good thing that we're part of that agreement now. All right. I could talk for days about that kind of stuff, but let's get into probably the things that you guys probably came for, was to know, down to the basics. What can I and cannot not use in a classroom setting, and that's what we'll focus the remainder of our time on is the things that are most likely pertinent to you guys. Okay, the biggest one you want to familiarize yourself with, the go-to justification of using copyrighted material in a class is fair use. It's called the fair use doctrine. It wasn't an afterthought. You remember the main intent of copyright is the furthering of knowledge. This was put in as an initial, frontline type of exception that educators have in their tool bag to be able to use copyrighted materials, but we have to hash it out. All right, we got a question here. Let me read it real quick. Copyright law hasn't been revised since 1978. That seems like a long time ago, especially with implications imposed by digital media and Web 2.0. Absolutely. I'll be interested if there has been any discussion of revising copyright law in the future. We're in total agreement. Yes, that's a long time, especially with the digital age now, and we're starting to see a lot more lawsuits ramp up. And in my opinion, here's why. even 10, 20 years ago, copyright law was important, but if there was let's say there was a violation, let's say in one of our classrooms, we copied something we shouldn't have or whatever, what's the worst impact that would have happened? It's limited to 10 kids, 20 kids, maybe 50, something like that. The impact was negligible almost. But you're absolutely right. It's becoming very, very important now because in the digital age with the web especially, you can copy and paste and post, and it's to the world, So you have these potential massive copyright violations that greatly affect people's market value, companies' ability to make money. I was tutoring a student a couple weeks ago, and it was in a math class, and I was doing it virtually. He was in where is he? He's at Vanderbilt, so he's in Tennessee, and we were trying to work through some problems from his textbook, and he's like, "Oh, here you go. Use this website." And he had found a website that had the PDF of his textbook. And I was like, oh my goodness. I was like, that's a huge copyright violation because what does that do? That affects our market value. How's a publisher going to make money if it's posted for free, at this website? So yeah, I hope that there are some clarifications coming with copyright law in the near future. There's a big copyright case that I referenced earlier, the Georgia State case that we're going to talk about, and that is live, fresh, hot off the press. Rulings coming down as in 2 weeks ago. Current rulings are coming down, and it specifically talks about fair use. I'll even give you a sneak peek of my next slide. It's about the Georgia State case and fair use. So we'll talk about that in just a moment. Okay. Got one more question here. I started writing a book and left it for 2 years. In the meantime, a famous author wrote a book that was very similar to mine. Would I have the right to finish my book? That's a good question. And anytime you hear a copyright attorney or a librarian or whatever, they're always going to tell you the same 2 words. Anybody know what 2 words I'm going to use? It starts with it. It depends. Yeah, it depends. So that's a good question. It depends. I would probably need to know a lot more detail about that. It probably has a lot to do with, could you show that you were working on it 2 years ago? Things like that. So that's something I would seek out a copyright attorney on if it's something that you're looking to finish, publish, make money on, things like that. Just my 2-minute answer probably would not do that justice. Yeah, but now I will say this: similar is totally fine. Remember, you can't copyright an idea, a concept, something like that. There was a lawsuit, a big one. I forget the name of the lawsuit, but someone had published a book on what was it? It was like how to keep records, it was like an office manual, for office type people. And someone else came along later and wrote a very similar type of book. And the court ruled it's fine. You can copyright your expression of that idea. They can copyright their expression of that idea. But unless it's the same, then yeah, it's totally fine. All right, so fair use, big one to familiarize yourself with. It's super helpful to educators. What fair use is this what's called an affirmative defense, which means you're using somebody's blatantly copyrighted material in your classroom. They come to you and they say, you can't use that, that's my copyrighted material. And you say back to them, no, I can, because I consider this to be a fair use. And fair use is a legal doctrine that has 4 criteria. So you'll never find someone, and if they do, they shouldn't, that will tell you, yes, this definitely is a fair use or this definitely isn't, because that's something you won't know until a court makes a decision on that, right? This is something that think of it like a spectrum. You can be way on the safe side, and I'll tell you, yes, that is very likely a fair use of that copyrighted material, or I can tell you that no, that's probably not a fair use, but you won't know a definitive yes or no until a judge rules on it, right? Because it's a defense. It's going in eyes wide open that you're using somebody's copyrighted material, but you're saying it's okay based on these 4 factors. It's called a 4-factor analysis. You make a judgment call as to how things weigh out. And I'll tell you the pros, what side you want to be on and not be on for these 4 factors. But ultimately, the decision comes down to your judgment call. Okay. Number 1, the purpose of the use. Why are you using it? Are you using the lyrics of a song to go make money, right, for like a commercial type of use? Or are you using it for a non-profit educational, type of purpose? The purpose of your use makes a big deal. Those of us in this room generally are very safe in regards to criteria number 1. Why? Because of what we do, right? We're part of nonprofit educational institutions. You can't get much better than that as far as favoring number 1. As you drift towards the profit educational institutions, it gets a little more gray. As you get to, fully profit driven, that sort of thing, that's where it gets into the negative side. Or now let me be careful with my words though. Just because something is being used for commercial purposes doesn't automatically nix it, interestingly enough. Have you guys heard of a company called Turnitin?
Yeah.
It's English, like you submit papers and then whatever. That's a commercial business. They got sued by a student one time. I guess parents were lawyers or something like that. I don't know. But the reason that they were sued was because what does Turnitin do? They take the paper, they make copies of it to put on their server, things like that. They're doing those 5 things, a lot of those 5 things that you wouldn't think that they have the rights to do. Duplicate, distribute, display, those types of things. And so they were sued. They say, hey, you can't do that. You don't have the rights to do that. Ultimately, the courts ruled that it was a fair use, and Turnitin was allowed to use the students' copyrighted term papers and things like that because the use was transformative. They were using it for a different purpose. Transformative uses are a big deal. If you're using it for a different use than what the original author, intended it for, it's by and large fine. And that's interesting because Turnitin is a commercial profit company, right? They make a buck. If you do a parody of something, it's almost always fair game, right? If you're critiquing something, if you're saying this is a bad example of X, Y, or Z, you can usually quote even the full item, the full article, the full book, the full whatever, because it's a transformative use. You're critiquing that work. It goes to the purpose of your use. Number 2, the nature of the work itself. Things that are nonfiction, like more factual, usually are fair game. Usually fair use is fine. If it's a highly fictional work, a novel with intricately developed characters like Mickey Mouse or things like that, usually those might be a little bit more protected. Things that are unpublished are more protected, like diary entries, things like that, as opposed to highly published, widely published, types of resources. One resource I use a lot in my class is, have y'all heard? I'm sure y'all have heard of the book, 7 Habits of Highly Effective People. Great book. It's been around for forever. They've sold a bajillion copies. Something like that would be, a more favorable fair use to use a selection of that than to use my grandmother's diary, entries. Number 3. Yeah, question. Yes.
I had a question. When you do the transformational use, I think we're talking about like examples of things and examples not to do. Do you also have to use a statement? Like, for example, when we were doing keywords, they had to type the paper. So I gave them a sample.
Yeah.
Statements and education just so.
Yeah, and you don't have to put that statement on the document or anything like that. it would just be a defense. Let's say, and I know exactly, for those of you who may not have heard, let me reiterate what she said in case you didn't hear it. She said if it was like a keyboarding class and you wanted them to practice typing, and you took a selection out of a Mark Twain book, or something like that, just to practice typing, that would be a classic example of a transformative use. They're not reading it for the reading enjoyment of Mark Twain. They're reading it, they're using it to practice typing. That would be like the textbook example of a transformative use. That absolutely. Yep. Yeah. Great. I'm going to use that.
To put that little statement.
No. Again, it's a defense. So if Mark Twain's representative, if there was some book of his that was still under copyright, because it may have expired. I don't know when Mark Twain died, but if some of his work is still under copyright, and whoever owns the rights to his books came and tried to sue you for using that book in your copywriting class or whatever, then that would be your defense. You say, no, actually, this is a fair use because it's a transformative use. I'm using it for a different purpose than just recreational reading. Yeah, great example. I'm going to steal that example because that's a great example. It's copyrighted. Nope, can't copyright an idea, right? Can't copyright an idea. That's slide number 2 or 3. Yeah, that's good. Okay, and number 4. Wait, no, I don't know if I really talked about number 3. The amount and substantiability of the portion used. General rule of thumb: less is better. Now, what is less? Can't tell you that, but you should take only as much as you need for your pedagogical purposes, right? No more, no less. I mean, less, obviously, if you want to take less, but no more than what you need. What you need might be 75% of the item, the text, the whatever, but it might only be 10%. No one should give you a percentage guideline. You'll see things thrown around a lot online, like a 10% rule or things like that. No such thing. Because you also have to account for the substantiability of the portion that you're using. Let's say there's some new book on the bestseller list or whatever, and everybody's buying it, and you want to use a little part for your class, but everybody's buying this, let's say, politically charged book because of one little paragraph, this kind of the zinger. Well, if you use that might be low in percentage or quantity, but it's big part as far as substantiability. Does that make sense? So you have to weigh that as well. It's something to be cautious about. Okay. And lastly, market effect. If you're greatly hindering the publisher from making money off of that work, it's going to sway against fair use. It very well could still be a fair use, but it's a 4-prong kind of balancing act, a weighing of these 4 things. These 4 things are not equally weighted either, right? And we'll talk a little bit more about that either. It's not 25%, 25, where you do the tally marks and see who wins. It's not like that. It's you have to take them in combination with one another. And we'll talk about the weighting of those when we get into the Georgia State discussion. Question?
If you're lecturing,
Mm-hmm.
and I don't lecture very much, so this is a relatively new question for me.
Okay.
Obviously, you're conveying content.
Mm-hmm.
That content came from somewhere.
Mm-hmm.
My own research to prepare to teach the class.
Mm-hmm.
How much am I supposed to say, so-and-so talked about Mark Twain and da-da-da, or the encyclopedia, not an encyclopedia, but like a critical biography encyclopedia said this.
Mm-hmm. Yeah.
How?
Are you talking about more like a face-to-face use or like distance?
Either way.
Yeah. Well, it's actually a little different. There's some different laws for face-to-face versus online, and we'll talk about that in a little bit. But face-to-face, by and large, you're covered. There's and I've got this slide in a little bit. Section 110-1 covers face-to-face courses, and most everything's fair game. You can show a whole movie in class. You've probably done that or seen that done. Face to face, if it's educational purposes, generally you're pretty okay. But when you put things online, it's a little bit of a different animal because a student could hypothetically take that copyrighted resource and then put it out to the world themselves. So,
But they do that when they take notes.
well, now also it could be their expression of that, because they could have a different expression of whatever is being talked about.
If you write it on the board, like there's these 5 elements that you need to pay attention to, and they're from, a 40-page article, but those 5 elements are there, and it's just an overview, and they're going to write those down exactly like that.
So like now is it like factual? Like
no, it's that's the point. It is factual, but it's from a scholarly article.
Because if it's factual, facts can't be copyrighted, as we talked about earlier. But I'm trying to think of like an example so I can wrap my mind around it a little.
Let's say a Freudian reading of Mark Twain. And a Freudian, this scholar says Freudian readings are 1, 2, 3, 4, 5. Is it important to give the name of that author that made that approach?
Now, personal copies are, for academic purposes, are generally fine. Like a student can go into a library and make one photocopy for themselves. Right. Things like that. So that to me would fall under that type of thing. Yes, it's like sense. They're not taking those notes. Now, if they took their notes and made copies of it and distributed it and sold it, and like you remember those 5 rights, those types of things, then that's a little bit of a different animal. But yeah, personal notes for educational type purposes, that's usually fine. And that I understand what you're asking now. That would be their justification, would be as for their personal, personal use. Okay.
Question number 5.
Yep. Absolutely. I see exactly what you're saying there. The 10% thing was shot down in the Georgia State case. Absolutely. Yep. I was going to mention the Georgia State thing in just a minute, but you're exactly right. My question as a librarian is, how do you make a reasonable assessment of the portion used without reading the entire work? Good question. I think the 10% came out of the fact that librarians don't have the time or means to read everything before it's placed on reserve. Great question. Don't have a great answer for that one. Again, being fair use, it's a defense where you say my use of this copyrighted material is a fair use because of, and then you would go through these 4 things, nonprofit educational institution, whatever, the amount or substantiability used. If you're making, are you talking about as a librarian putting things on reserve for an instructor? Because if that's the case, then I would leave that up to the instructor, would be my thought. Because as a librarian, you're not going to read or maybe even understand, some Greek, whatever. You may not know what substantial means in that particular field. But being that you're talking about putting things on a reserve, I'm guessing you're talking about something for an instructor. Yeah, I think this is Brandy. Faculty bring items to put on reserve. The library establishes criteria for what's acceptable. Yeah, that's difficult because there is no percentage rule, and you're exactly right about the Georgia State case. I'll skip ahead to a punchline. In one of the rulings that came out in the court, the judge came out with this 10% thing, and most people who were following the case raised an eyebrow and said, you can't do that, because it's pretty widely known. There's no such thing as a percentage number you can put on these things. and eventually that particular item, the 10% thing, got shot down on appeal. And so yeah, there is no percentage, type of rule there. And the people who designed the fair use doctrine, they intentionally left it broad. They intentionally left it open, so that things can be handled on a case by case type of basis. So I'm sorry I don't have a better answer for you. I would love to know just a flat number, of how to account for substantiability or amount, but that general rule doesn't exist. Okay. I don't think I'm going to actually go to this PDF. I will click off, and I do want to show you some websites later on, but this one is probably not worth the technical trouble to get there. There's a guy, his name's Kenny Cruz. He's pretty much a rock star of copyright. He worked at Columbia University for a long time, for like 20-something years, really like a go-to guy as far as copyright is concerned. He recently moved on, and now he's a consultant for a law firm on copyright and that sort of thing. But he made this thing, and it's an active link in that document there. But you can just Google Kenny Cruz fair use checklist, and it'll definitely come up. But he designed a checklist that has pros and cons for favors or goes against fair use. And he goes through all four of these: the purpose of the use, the nature of the work, and things like that. So if you have a copyrighted work that you're trying to make a decision on whether it's a fair use or not, I would encourage you to use his fair use checklist just as a starting point to say, yeah, this is probably a fair use, or no, this definitely isn't a fair use. And that fair use checklist is Creative Commons licensed, so any of us can use it. It's that's what I was talking about earlier, where when you want to make things freely available to other people, you can put a Creative Commons license on it. And we'll talk more about Creative Commons in just a little bit. Okay, so let me stop there, see if there's any questions.
I have one. I was using a line from the movie Steel Magnolias.
Uh-huh.
And I went ahead and I didn't want to say it was from Steel Magnolias, but I had to, because put quotation marks around it.
Mm-hmm.
Was that the right thing to do?
Yeah. Yeah. Now, an interesting thing about attribution, a lot of people think that just because you attribute a work and say, well, I'm using this, this image, but it's from so and so. Legally speaking, that makes no difference. If you don't have the rights to display that work, I mean, it might still be a fair use, and you can still use it. But the fact of having an attribution or not doesn't really make a lot of difference. You can't just put whatever you want anywhere as long as you cite it or attribute it to whoever. That makes very little difference. The only place where it might make a slight difference is part of fair use is showing a good faith effort, and part of that good faith is attributing, certain works or whatever. But it's minor. It's people think that's you do that and you're good. No, that's not true. Okay, so let's talk about a live, ongoing, fresh application of what we just talked about. Georgia State University was sued for copyright infringement. Are you all familiar with e-reserves, like libraries and whatnot? Our librarian friend here, Brandy, is obviously familiar with this, as are a lot of librarians. A lot of people around the country have close eyes on this particular case. I'll give you the short version. I'll give you the Cliff Notes version. 3 publishers sued Georgia State for widespread, basically copyright infringement, for making a lot of these publishers copyrighted material available too widely, and so they were sued. Interesting backstory. These 3 publishers are being funded by somebody called the Copyright Clearance Center. It's somebody you probably want to familiarize yourself with. Copyright Clearance Center is an organization who partners with publishers, and they license the publisher's materials. So they're kind of like a one-stop shop. So if you wanted not fair use, if you wanted to go buy a license to use X, Y, or Z, chances are you could probably go to the Copyright Clearance Center, and say, hey, can you give me a license to use this material? They'll sell you one. Okay. Now, they're good and they're bad. A lot of librarians do not like them at all, because you can see how you could very easily pay for something that you should have free rights to use. You shouldn't have to pay for something that should come free legally via fair use, for example. But on the other hand, they can be convenient, and their convenience they often exploit a little bit, because they can go to a school and say, hey, you buy a license from us and you're good. And so you see how tempting it could be for a school just to say, pay the money, be done with it. But fair use is kind of like a muscle. If you don't use your muscle, if you don't exercise your muscle goes away. And so, something people have been very cautious about with the Copyright Clearance Center. And anyway, long story short, Georgia State did not want to play with the Copyright Clearance Center. They said, no, we're not going to buy your license. And so what came next, repercussions in the form of a lawsuit. So the Copyright Clearance Center is not suing Georgia State, but they are paying the bill for the publishers to sue Georgia State. All right, so that backstory kind of makes sense a little bit, right? About 2 years ago, the ruling came down from the courts, highly favorable for the academic institution. The publisher sued initially over a god-awful amount of copyright infringement claims. They whittled it down to 75. Out of those 75, the courts ruled that 70 of the 75 were fair use. Okay, big win for the library, big win for Georgia State. The whole nation was pretty excited, the academic people, because it was a big win for fair use. They were a nonprofit educational institution. Those 4 factors, by and large, went towards Georgia State, towards Georgia State, towards Georgia State. There were only 5 that were considered legit copyright infringements. Okay, there were some quirky things that came out in the ruling. The 10% thing I mentioned. Everybody who was watching it was like, "What is that?" Like, obviously, the judge doesn't, miss that part of fair use, because you can't put a number on amount, and a few other minor things, but by and large, big win for the academic institutions. All right, slightly worse news. About 2 weeks ago, well, let me back up. They appealed. Obviously, they lost, so everybody appeals when they lose. About 2 weeks ago, a ruling came out from the appellate court. The original ruling got overturned. Okay, the ruling that the 70 wins and 5 losses or whatever, that whole ruling got overturned. They made some affirmations of what the lower court ruled. They revoked some of the things that the lower court said and remanded the whole thing back to the lower court to be reviewed again. All right. I knew I'd forget some of these highlights, so because it's so fresh, I'll just read a couple of these highlights. I already mentioned the appellate court nixed the 10% thing. They said you can't do that. You can't make a percent, type of ruling there as to whether something's fair use or not. Technically, what they had said was the judge had said 10% or 1 chapter, if it's like a book or something. Okay, a couple other highlights that came out of the appellate court's reversal. They said that the lower court judge should have given more emphasis to the 4th factor. The 4th factor was about market value, remember? The lower court judge basically took all 4 as kind of equal weight. And the appellate court said, no, you need to put more weight on the 4th factor. That's more important to us. And the reason these court cases are important is because this is the only place where we get any additional clarification. The only way we get additional clarification about fair use or copyright is through court judgments. And so that's why this is so important for you and for me. Now, the last thing I just said there about market value is very challenging for us. Here's why. Let's say you've got an instructor in a class and they want to know about using Mark Twain, or they want to know about whatever. how in the world are they supposed to know about what the market value is for, or you can't reasonably add, and I'm just kind of talking off the cuff here now. Now I'm just, just between us, we're just talking. How is an instructor supposed to know anything about market value? They're content area experts. They're not economists. They're not. So to ask a librarian, like Brandy, or ask an instructor to weigh as they make their fair use decision the market value as to what that is. I think that's very challenging to ask an instructor to do, personally. Another thing that they highlighted was that kind of goes along with that market value thing. For digital content, which is applicable to us for distance ed classes, if a license is available, then in not so many words, you should probably get the license, right? So what that means is if you're wanting to use some digital resource and a license is available, a digital license to go and purchase, and it's readily available and not overly expensive, then the courts are going to start expecting you to go get the license to use that work. The challenge there for instructors is going to be, publishers don't have to make things easy to, necessarily to find. So how do you know if a license is available? Those sorts of challenges are going to be things that have to get hashed out. And this is, like I said, this is fresh, 2 weeks ago, fresh. So a lot of things are being hashed out in the blogosphere, with, librarians and whatnot, even in, recent days about this latest rule. Another thing that the appellate court hit was that, actually, no, this was affirmed, but the lower court said this and the appellate court affirmed it, is that hit counts matter. If you have digital content in your distance ed classes, how many people access that makes a difference. Because let's say you put a blatant copyright violation out on your Blackboard class or whatever. If nobody ever clicks the link, then it's not really a copyright violation if no one's accessed the material. The mere presence of certain material on there in and of itself doesn't really make a violation until people have accessed that material. Does that make sense? It's kind of a weird one, but it should be noted. Okay, the appellate court did affirm nonprofit educational use is very important when deciding a fair use. And another good thing for us is they also affirmed that when you're looking at fair use is always done on a case-by-case basis. What the publishers wanted the courts to do is to take the violations or supposed violations as a whole or as an institution and make a blanket statement, bad or good or whatever. But you can't do that. You have to take all 75 cases, judge them on their individual merits, and do it that way. And that's the way it should be, is on a case-by-case basis. Okay, any questions on the Georgia State deal? Okay. I know fair use sounds scary, especially when you hear about people like Georgia State, but I would just encourage you to not give up on it because it's an exception carved out in the law. It's for us, it's to further knowledge. We as educators do have rights to use materials for educational purposes. So remember my analogy about the muscle. If we as educators, I teach an online class too. If we don't continue to use it, it's going to go away. So I want us to not throw up our hands and say whatever, we'll pay for it. Whatever. We do need to pay for what we need to pay for, but we also need to take advantage of the things that are free if we're legally entitled to it. It's just people are getting more and more gun shy about even, going that route. Okay, let's talk a little bit more about face-to-face versus online, because there's a big difference there, big difference between face-to-face and online. Title 17, Section 110-1, you don't have to memorize that legalese or whatever, but this is what you've probably heard of for a long time. Maybe you just didn't know where it came from, but it's fairly widely known. In summary, and I hacked out a lot of the fluff, but the meat of it says the performance or display of a work in the course of face-to-face classroom teaching at a nonprofit educational institution in a classroom is not an infringement of copyright, right? You can show movies in class, you can do all those kinds of things fairly safely in a classroom. Okay, it's limited to your students.
If you purchased it.
No, I'm talking about like fair use. No, this isn't fair use, but this is carved into. Yes, if it's legally purchased.
Right.
Okay, I'm sorry. Yes, let's say you're using like a movie or whatever. It can't be like a bootleg copy, or something like that. Hopefully, you wouldn't do that anyway. But as long as it's as long as it's legally obtained,
Okay.
yes, then you're pretty, by and large, good to go.
You're
Yes.
saying like if you're renting it?
Renting. I'm not sure about renting. That's a good question because you don't own it. I would probably get a legal copy of it to be on the safe side because it's not going to be that expensive. But that's a good question. I would probably need to look in on that one a little bit before I gave a firm answer. But it needs to be a legally owned copy of the work. Yep. All right. But the point I wanted to make here, we're not going to spend a lot of time here, is why is this not applicable to distance ed? It's not face-to-face synchronous teaching in a classroom. It could be asynchronous in a Blackboard classroom or whatever. And it's a little riskier in that environment because in the digital environment, there's a lot more opportunity for copyright infringement, even by your students potentially or whatever, or yourself, like that PDF of the textbook I talked about. You can't just take it and just put it online like that. That would be a big copyright infringement. Okay. So there was an amendment that was made to Title 17, Section 110-2 that specifically addresses online courses. So this is the one that's applicable for us. It's called the Teach Act. Okay. Not a lot of schools utilize the Teach Act. I think, especially with fair use being under attack a little bit, like the Georgia State case and whatnot, I have a feeling more distance ed people will start using the Teach Act than they currently do. But the reason more people don't use the Teach Act currently is it's a bit unwieldy. It has pros and cons, in my opinion. The good thing about the Teach Act is it's more of a checklist. You do this, and this, you can use it, right? That you don't get with fair use. Because remember, fair use is kind of gray, it's on a spectrum, and things of that nature. But the Teach Act is a big checklist, 20, 30 things. But the tough thing is that it has requirements for you as an instructor, but it also has requirements for the institution as well. And that makes it more challenging because you have to enact some things at your school before you can invoke the Teach Act. What I'm going to say here today, because the Teach Act is so involved, use what I'm going to say here today as a primer on the Teach Act. Don't run off and do it until you've read a little bit more about it. I'll give you the highlights of the Teach Act. Okay. First thing is what Veronica highlighted just a second ago. The resource must have been lawfully obtained. Okay. No bootleg, nothing like that. Okay. Second thing, here the institution has to be a nonprofit educational institution. For-profits cannot invoke the Teach Act. Okay. A few other highlights of the Teach Act. The materials made available are limited to only students in your class. For example, posted within Blackboard or something like that. 5-10 years ago, a lot of people were running online classes just through like personal websites at the school. You couldn't have used the Teach Act in that environment because it wasn't locked down to your students, which makes sense. I mean, that's a reasonable expectation. Okay, an institutional policy, the entire college has to have policies regarding copyright and provide info to faculty and students about copyright law. There's got to be some education that happens there, both to the faculty and to the students. Third one, notice has to be provided to the students in that class that some of the materials in that class might be copyrighted, so that they know to not download that PDF and then go upload it on Facebook. Like, hey, check this out, guys. They need to be made aware of that. Okay. And the reason that a lot of schools don't use the Teach Act is the last item. The last item is the most challenging. It's possible, but it's challenging. The college must reasonably prevent further dissemination of that work by students, and that's called downstream control. A classic example would be like a video. If you take a video file and upload it, and the students download the video to watch it, then they could take it and go send it wherever. But if it's being like live streamed, like a live streaming video, then under most circumstances, a student can't take that and disseminate it anywhere. It's being streamed. Okay. Now, I like how they say reasonably prevent, because even streaming video, if you have a technologically astute student, they can capture that stream, but that's beyond what a normal student would know how to do. Does that make sense? So they don't say absolutely, they say reasonably prevent, downstream control. Okay. But if you have those types of things enacted, then you have justifiable use of copyrighted materials, in your course. In effect, the way I kind of view it is it almost makes it more in line with the face-to-face type of thing. They're protecting publishers' content from flying out to the world. That's really the main intent behind that. Okay. If you want to know more about the Teach Act, there's a link right there on the page. NC State has a great resource. It's called they call it the Teach Act Toolkit, I think is what they call it. But they have gobs of information about the Teach Act. They have the checklist that I referenced. So you can print off a checklist and say, yep, we've got that. Yep, we've got that. Yep, we've got that. So I would encourage you to check out NC State's Teach Act Toolkit if that's something you want to know more about. Okay. Questions on the Teach Act or fair use before we go on? All right. Okay. Here's a bulleted list of the thought process that should go through your mind before you pull the trigger on using a copyrighted material in your course. Number one, is it copyrighted? Right? Does it even have a copyright? Because remember, if it's in the public domain, you don't have to ask anyone. A lot of popular works are in the public domain. Beethoven's music, public domain. The Mona Lisa is in the public domain. Things of that nature, they're in the public domain already. If it is copyrighted, if it's life of the author plus 70 years, if you're still in that window and those types of things, then you can ask, is there an exception for your use, for a teaching exception? Fair use and Teach Act would be the two you would want to look at. Okay. Some people interchange 2 and 3. I like to look for an exception first, but it's totally understandable if you want to flip-flop 2 and 3. You can ask permission from the rights holder. You just ask them, hey, do you mind if I use this resource? Or you can seek a license. Copyright Clearance Center, I've heard them called a lot of choice words, but they are a resource that are there for licenses. Love them or hate them, you can get a license through them to use a lot of resources. So they can be a one-stop shop. Go get your license and then have a good night's sleep, with a clear conscience. Or if that doesn't work, and you don't have an exception and you can't get a license, and they won't sell you a license, and the publisher says no and that sort of thing, then you can look for a different resource to use. I wanted to throw these in here. I didn't really have a great place to put them, so this is just kind of where I squeezed them in. Figured it'd be a good place as any. A couple of things to keep in mind as educators for your classes. I like to caution my faculty to just be cautious with materials that are coming from publishers. I'm not saying don't use them. They're great. But I'm just saying just be careful, and if anybody at any time came to you and said, hey, why are you using this copyrighted material? Because if it's from a publisher, it's not yours. You don't have the rights to it. We all know that. Be able to give an answer, right? That's all I'm saying. Very often, publishers will give faculty like teaching resources, like PowerPoints, things like that. Make sure you've just read the licensing agreement. Are you allowed to use that in a classroom? Probably so, but still find out. Are you allowed to use this only in a face-to-face classroom, or are you allowed to upload this to Blackboard as well? Those are things you got to know, because there could be a big difference there. So read your licensing agreements. Know what you're allowed to do and not with your publisher's material. What about this? What if you're using a textbook one semester? Publisher gives you all sorts of supplemental PowerPoints, that sort of thing. Next semester, you go with the Wiley book instead of the Pearson book. Are you still allowed to use those, PowerPoints? Does your license run out when you no longer adopt that textbook? Those are things you have to think about as you're developing your online courses. I don't know if this is applicable to you guys, but at Midlands Tech, our LMS has a repository. It's called a learning object repository, which basically is a big, basically think of it as a big thumb drive for the college for people to take resources and put things into. You may or may not be allowed to take those PowerPoints and stick them in there, because then maybe you're making them available to people outside your teaching class. Just be aware. Think about what licensing agreements you have with publishers' materials. Okay. I get a lot of questions about YouTube. People are very hesitant about using YouTube, either about using other people's YouTube videos or about the rights that YouTube has over your videos. I get both questions. And I would encourage you to read YouTube's terms of service on your own. It's very short. It's very plain English. It's not legalese. It's very easy to read. But by and large, I don't have much issue with YouTube's terms of service. They're very reasonable. In general, if you link to someone else's YouTube video, you link to it, you're generally safe. Why? Because that user has given YouTube the rights to show their work. That's kind of the whole point of YouTube, is to show their videos. And if you're either linking to or even embedding that video in your course, that's fine. It's YouTube showing that video, right? It's coming through YouTube servers. Basically, think of it this way. If you unplugged your computer from the internet, would it still work? No, it wouldn't. Why? Because it's YouTube displaying that, that material. So by and large, if you link out, that's safer. Now, if you download their video, then what have you just done? You've made a reproduction, which you don't have the rights to do. If you upload that, then you've not only made a reproduction, but now you're also displaying the work. It's you displaying it, not YouTube. You see how you can get in trouble? To an end user, they look identical, but behind the scenes, big difference, right? So that's why linking is generally safer than downloading someone else's video. All right. Now, as far as posting your own video, YouTube is pretty fair. They basically say, and I'm summarizing here. If you have questions, read it yourself. But basically, in summary, YouTube claims a right when you upload a video that they have the right to display it. To me, like, it's kind of duh. Well, obviously, they would have to have the rights to display it. That's kind of what you're using them for, to reproduce it, basically everything, to distribute it to people around the world, But they also say as soon as you take your video down, their rights cease, right? And so, really, what more could you ask for, beyond that? They say something to the effect of in a commercially reasonable time. So it may not be instantaneously, but when they get it down, it'll be down. Now they do store a copy on their servers, but they say that they are no longer allowed to display it or show it, that sort of thing.
So you were talking about the display, I was thinking about your security settings, because you can make it public or you can make it restricted.
Yes.
And then you can also do it
Unlisted.
restricted only.
Yeah, unlisted. My favorite of those three, and the one I encourage my faculty to do, is the unlisted. Just to repeat what she said is, you have three options on YouTube. You can make it public, you can make it private, which is like password protected, or you can make it unlisted. The reason I like unlisted is you don't have to distribute passwords to everybody. But then number two, it doesn't show, for all practical purposes, it's private because it'll never show up in a search engine. It'll never show up on Google, YouTube search, or anything like that. So it's what's called security by obscurity. No one's ever going to find it unless they have the link. So, that for practical purposes, that suffices. Is Vimeo similar? It's funny. If you look up Vimeo's terms of service, it's almost a carbon copy of YouTube's. It's almost word for word identical. It's the exact same language as YouTube's terms of service.
Add something to Winona's question. If you're using Blackboard to post your YouTube videos that you created, you have to mark them unlisted anyway, or else they won't show in Blackboard. Blackboard has a YouTube integration.
Mm-hmm.
And so once you do that, if you mark it private, it won't find it. But if you mark it unlisted, it'll find it, and you can pull in your YouTube videos into the learning management system.
Okay. For those of you who missed that dialogue there, Veronica was just saying that Blackboard has a feature where it will only show in Blackboard if it's unlisted.
If it's unlisted or public.
Or public. Okay. Yeah, I was about to say, because you could obviously post public videos as well. Okay, but it can't be private.
It can't be private.
Can't be private. Gotcha.
Since you use D2L amendments, right?
I do.
So is that the same?
Um,
I know we use Couture to upload ours into, but
Now, are your videos private, or?
something that I'm thinking we just put the link in.
Yeah, public or unlisted is fine, because really unlisted is public, just without any publicity, right? No, it won't show up in search engines and things like that. Anyone can see that video if they have the link for it. Okay, I'm going to kind of speed up a little bit. I can get through the rest of these fairly quick, so I want to leave some time for questions if we have any. Who owns copyrighted material? This is really interesting in the academic environment, and it differs school to school. All I want to say is to seek out what your school's policy is. There's a spectrum here. Let's go through this list real quick here. If nothing else is in play, whoever makes the work has the rights over the work. If I'm at my house and I draw a painting of an apple, then I own the rights to that painting. So unless some other function is at work, the creator of that work automatically has the rights to that work. Someone else could own all the rights to that work if I transfer my rights to that person. Like my children, if I transfer my rights to them in my will, they can own it. I can license certain rights to you for my work. That means you don't own the work or the rights to the work, but you have certain rights that you can do with that work. Work for hire. If let's say there's a software company, and a software company, development company, is working on a new piece of software. Those developers, a developer at his desk, as he finishes that piece of software, that developer obviously doesn't own that software. The company owns that piece of software, right? That's pretty clear. That would be considered a work for hire. Let me finish this list, and then I'll come back to work for hire, because we need to talk about that one. Heirs, we already talked about that one. Maybe no one owns copyrights if it's in the public domain. Now, work for hire is interesting in the academic environment. Different institutions are on different ends of the spectrum in regards to work for hire. Typically, large four-year universities, lecture style, things of that nature. Usually the faculty have a lot more pull than like a small community college or something like that. It differs institution to institution. In some institutions, the faculty own the rights to their academic, scholarly types of works. I've seen other schools that say anything that any faculty or any staff member makes is work for hire, and the institution owns the work. I've seen both ends of the spectrum. I would just encourage you, just because it's good for transparency, it's good to know, distance ed courses in particular are a lot of work to put together, as you guys know. So you would not want to think that one person has all the rights to this, staff, school side or faculty side, and then suddenly you find out that the other side is actually the rights holder, right? And it could go either way. Schools invest a lot of money in developing courses, instructional designers and things like that. In some cases, the school may need a certain rights to that course and the things that are developed because they invested thousands of dollars in developing it. But then on the other hand, instructors also put in a lot of work and blood, sweat, and tears in developing that resource. It's possible to do joint ownership, but that can be really tricky. Generally speaking, the rights lie in one place most of the time. There are cases where you can have joint ownership, but those are the things you just want to learn about at your institution and hash out, just so everybody, just so you don't have a bad situation down the road. Okay, so that's just something to keep in mind. Okay, this is one that's often forgotten and not thought about. Students have rights. If a student makes a creative work, a painting, a sculpture, even a term paper, things like that, even a discussion post in Blackboard, things like that, those things have copyrights on them. Why? Because minimum level of creativity, right? And they're in a fixed, tangible medium of expression. That's all you need. There's nothing at any institution I've seen that says the schools have the rights over students, whatever. That's generally not the case. Usually students, have the rights to their materials. The students aren't employees of any college, or things like that. Now, why do I mention that? I've been guilty of this in the past. I want to just warn you about it as well. I'm sure we've all done this. You have that great student one semester who makes that awesome term paper, and then the next semester you say, hey guys, y'all look at this. This is great. Look at what a good job Susie did, on this paper. See this, she did that. What are you doing? You're displaying the work, possibly replicating it for copies for people. You're doing the things that only Susie has the exclusive right to do. So you just have to be careful about that. I actually saw a faculty member's class last week where they had taken someone's work and put that up for their class to see, and we're in the, I haven't heard back, but I was just curious if she had asked permission from that student. Now, 9 times out of 10, if you ask a student, hey Susie, do you mind if I show yours as a good work? Of course they're going to say yes. They want to impress you. They want to impress their classmates. Normally they're not going to have any problem at all with it. but you want to make sure you get that in writing. And by the way, a lot of legal things can be agreed upon word of mouth with a handshake. Copyright cannot be transferred unless by writing. So just because Susie says, "Oh, sure, that's fine, go ahead," you need it from Susie in writing. Okay, we got a question. What if there's a statement in the syllabus indicating that the instructor reserves the right to use the student's work? That's a good question. One interesting thing is schools can make policies all they want, right? You can say anything you want as a policy, but you won't know really how it'll come down until it until it goes to the courts. So I think that would go a long way towards putting you in favor of using a student's copyrighted work, like a term paper or whatever. But I would still be very hesitant, even with that statement in the syllabus, posting or displaying a student's artwork or anything of that nature without permission from the student, personally speaking. Okay. Yeah, I'll give you a good example. I actually had this happen this semester. I was teaching an elementary calculus class, which is a really challenging class for our students because it's calculus for people who don't like math. They're either business people or biology, and they just need a calculus, but they don't want to take the big calculus, so they usually struggle with it. Well, this girl on the first test did terrible, bad, low grade. Second test, she got 100 on the test. So I email her back. I say, "What did you do?" I was like, "That's awesome." And the tests are proctored and all that. It's just, I know she didn't cheat, but I was like, "That's excellent. You did such a good job." And she emailed back, let me back up. Before the second test, because a few people didn't do well, I said, "You need to be watching the videos. You need to be reading ahead of time. You need to do whatever." And she replied back and she said, "I just did the stuff you told me to do." So I was like, "Nah, how about that?" So I wanted to take that and send it to the rest of the class, but I could not have taken her email, copy, paste, and send it without her permission. And so I asked her permission. She said yes, and off it went. Even if you take their name off, that doesn't matter, right? It's still their copyrighted work. Because I've done this before. I've blacked out the name, showed it, doesn't matter. I shouldn't have done that. It's still their copyrighted work.
So she emailed you back and said, "Yeah, sure, you can forward this to the whole class." That's good enough.
Yes, written email. Yep. Mm-hmm. This one I just want to put on your radar. I don't really want to talk about it too much. Talking about intellectual property rights and copyright violations, this company here majorly copyrights probably your copyrights. This is a website. It's called CourseHero.com. I looked it up as just an hour ago. They have a website on USC Aiken. The way the website functions is they are a repository for students to upload instructors' notes, instructors' PowerPoints, instructors' videos, anything they have in class, they can upload it. Tests, quizzes, anything from an instructor. The way that you get membership to this site is you have to bring something. You have to bring something from your instructor. So I look, there's stuff from your English department on here. There's stuff from your biology department. USC Aiken, right? There's some of my stuff on here. So they're getting lawsuits left and right. But just to show you how badly copyright can be violated so quickly and easily with a click of a button, there's a link here. I'm not going to click out to it, but yeah, USC Aiken has a site there with your students uploading your instructor's content.
I mean, can we go in and look and see what's
You can see everything in there. Yeah. They give you a little preview. You can't see the whole work, but you can see enough to know, hey, that's my quiz from last semester, and it's on there.
Yeah, we actually had a student come to us and say that some of our tests have been leaked.
Yep, and that would be where. Yep.
So even with us making them leak their cell phones and their backpack
Yep.
at the door, I mean, everything we've
Yeah. Well, even if you give them the copy, even if it's after the test, and you give them the copy of the test, they can go home, scan it, and upload it.
We never let them take tests out.
They don't even allow them to take. So, yeah, they
So
get out
we're
somewhere.
not quite sure
Midlands
how
Tech has thousands of.
Somebody has slipped a phone. Even when we make them leave their phones in their backpack by the door.
Yep.
Somebody slipped a phone.
Yeah. First time I saw the site, first thing I did was I went to the math department, which is where I was teaching, and I was like, that's my Calc 3 handout. What is that doing in there? But somebody had taken my handout and uploaded it, and then so yeah, you have to be careful. Yeah, you have to be really careful. And when I say be careful, there's not really anything you can do about it. I mean, if people take your stuff, but I mean they're starting to get a lot more lawsuits. Yeah. This one I already mentioned. Copyright notice is optional. You don't have, you used to have to put the C and the whatever. Your stuff has rights automatically. Now, if you want to seek damages from somebody, then your work does have to need to be registered with the Copyright Office. But just to have a copyright, it does not need to be filed. Owning a copy does not mean owning a copyright. We already talked about that as well. If you own a copy of a book, that doesn't give you the full bundle of rights that the copyright owners have. This is an interesting one. State agencies have immunity from copyright lawsuits. Now you might say, well, wait, what about Georgia State? You can't seek financial damages from a state institution, so you can't go sue a school for $1 million. That's refreshing that you shouldn't have monetary damages be awarded. The reason that the Georgia State case has continued to go on is they're not looking for monetary damages, they're seeking injunctive relief because they want them to buy the licenses. That's what they're after. But they're not suing Georgia State for $1 million. Now, indirectly, there are financial repercussions because attorneys cost millions of dollars. And so there is a financial angle to it, but they're not suing them for millions of dollars. Another very important thing, that sovereign immunity granted by the 11th Amendment. By the way, time out. What is 11th Amendment? 11th Amendment protects states from federal prosecution. So since copyright would be a federal lawsuit, it protects state universities, Midlands Tech, USC Aiken, it protects us because we're state entities. We're being protected by the 11th Amendment from federal, lawsuits. Now, that sovereign immunity, however, does not extend to individuals. It gets extended to the college or the university, but not to the individual instructor. So they can still go after an instructor as an individual for copyright violations, which is good to know. Okay. We talked about this briefly. Attribution does not equal fair use. Just because you say this image came from this place doesn't make it fair use. That's a very common misconception. It plays into the decision of whether it would be a fair use, but it's not a one and done where you cite it and you're good. That's not true whatsoever. Okay, Creative Commons, I don't know if you have seen these symbols before on documents, but I would encourage you, if you have educational material you would like to make available to the world, put a Creative Commons license on it. In short, it basically just says anybody can use, like this PowerPoint here. If I put a Creative Commons license on it, I'm basically saying anybody can use my PowerPoint. You can use it, you can take it, you can edit it, copy it, delete slides, do whatever you want, as long as and then I would pick one of these. If the top one is the most wide open one, as long as you attribute me, as long as you say, this came from Devin, but beyond that, I tweaked the heck out of it, right? You've attributed me, but beyond that, you've got full license to do whatever you want with it. And then you've got it's like a buffet, other options of how you want to license it. You can say, You can use this work, but you can't make money off of it, right? Just as long as you don't commercialize it, you're free to use it. You can use this work for free, but you can't make any derivative works from it. So don't change it. You can't delete any slides, but you're free to use this. Those types of things. Okay, so that's a great tool that we have.
Devin, let's say your works was on Creative Commons and a person did not attribute you. You found out.
Then you could proceed now to, now that would be a tough one because you put in Creative Commons, which is one step short of sending it to the public domain. So it would be almost silly to seek a lawsuit for that.
Okay.
But yeah, it's possible because the license, it's got one requirement. You just got to attribute me. And so if they don't meet that licensing requirement, technically, yeah, you could go after them. Your work would have to be registered with the Copyright Office, but sure, you could go after them, yeah, as long if they don't attribute you.
So if somebody got something from Creative Commons and they attributed it, and it was the wide open option,
yep,
they could change stuff and
change
they could
it,
say
yep,
something completely different. But if it's attributed to, I don't know, Albert Einstein,
mm-hmm,
we're gonna say, hey man, he knows what he's talking about. This must be right. So
yeah.
I mean,
Now,
there's
if
a
they
lot of
make
risk.
derivative works, then that's a good question because then you wouldn't want them. In that case, if you're worried about that, you would probably just want to say no derivative works,
But if
because
you find something and it's attributed to somebody,
mhm,
it may not really be their work.
it may be an altered version of their work. Yeah, that's a good point.
So, I mean, that's a concern if
Yeah.
you're
Mhm. Yeah.
looking for
Because
scholars.
it's kind of a catch-22. A lot of times you want people to be able to adapt it to their needs.
Yeah,
That's kind of the whole
yeah.
point of Creative
And I'm
Commons.
sure 99% of the time that they're going to use it like you or I would use it. They're going
Right.
to tweak it a little bit
And-
for an audience.
and
or they're not
actually-
going to change the substance.
There's a picture back here. What is it? One of these, it said like original or something to that effect. But yeah, there should be some way to identify that there's been some adaptations, to that work. Because yeah, I definitely understand what you're
Make
saying
you a
there.
little cautious about using
Mhm.
things.
Yeah.
I mean,
Yeah.
Even more cautious.
Right. Now, another thing is oftentimes I use images a ton, in courses or whatever. Do not just go to Google search just blanketly and start grabbing stuff because chances are it's probably copyrighted. We heard in an earlier session you can filter by things that are copyright free. I would still be very cautious about that because says who, right? So who says. I would go an extra step and make sure, that sort of thing. But this Creative Commons search is a very helpful tool. Just Google it out. I won't say too much more about it, but you can find copyright-free images. I just want to make sure we have enough time to finish. Okay, last slide. Because copyright is becoming so big of an issue in the distance ed classes, I'm becoming a bigger and bigger proponent, as well as Tucky, who will be here on Wednesday, of these things called open educational resources. OERs, as they're known as shorthand, are basically resources that have been developed that are accessible, modifiable, adaptable, and shareable by anyone. Think like Creative Commons, but think of like a whole textbook being Creative Commons, right? There's things that people have developed. There's a lot of grant money out there now. Millions of dollars are being invested in these resources. See, OERs used to be kind of crummy. You had like these big, nice Pearson books with colors and whatever. And then you had this rinky-dink textbook that was an OER that somebody in their office made. That's not true anymore. These are good stuff now. This is peer-reviewed, high quality, good images, the whole 9 yards. Comparable to a Pearson, a Wiley, a whatever. They're good stuff. And you don't have to worry about copyright with these resources. Because who would sue you? It's open. That's the concept of an OER, is that it's open, shareable, or whatever. So it solves a lot of our problems. Now, another thing I'll just mention on the fly because I know I got to wrap up here is it because they're free or very very inexpensive, $10 versus 200 for a textbook. I imagine it will also increase retention because I think a lot of students don't buy the textbooks because they cost too much, and that hurts. They're going to drop the course because they don't do well because they don't have the book. So I really think OERs could be a solution to retention issues as well. Um, Now, a lot of schools will give some pushback to OERs because bookstores make money, and they're often a big money maker for schools. So we have to find the right way to implement it. But I would just encourage you and Veronica and the people who do in distance ed to look at OERs and feel it out and see how you might can use it at your institution because they would solve copyright, they would solve retention, that they have a lot of good things going for them and they're very high quality now.
And since you said that it's modifiable, even if you find one and you tweak it a little bit,
Absolutely.
out of ethics, you would still attribute the originator?
You could, but yeah, these OERs. Let's say you have a textbook, but math is a great example. A lot of times in these algebra books, you never cover the last 5 sections. Usually they're higher level. You can just take them out, right, and have a condensed, book for your needs. So you can take out chapters. You can tweak it as needed. I've got some resources. I didn't put them on the slides. If you want to jot them down, I'll just give you some big ones. MIT Open Courseware is a great one. That's the first OER I ever found. Basically, they got some money to put all of MIT's courses online. So you can see instructors teaching calculus. You can see, great resource. And my current favorite one is Rice University has something called OpenStax. It's OpenStax. OpenStax. Great, high quality, free textbooks. I would encourage you to check those out as well. They've got English, math, history, psychology, the whole 9 yards. Great resource. Okay. Yes, MIT Open Courseware, and then Rice University OpenStax. Okay, I am out of time. I'm actually over time, so let me stop right there. I can answer questions, or we can break. But that's all I've got. Thank you guys for being here today. I appreciate the invite. Okay. Any other